Good afternoon, everyone. On behalf of the Center for the Study of the Public Domain and the Intellectual Property Law and Cyber Law Society, I am thrilled to introduce to you today Jonathan Band. Mr. Band has been involved in many of the major intellectual property debates over the past decade. He represented clients with respect to the drafting of the Digital Millennium Copyright Act and database protection legislation, among other statutes, and has filed amicus briefs in cases ranging from Chamberlain versus Skylink to Daystar versus 20th Century Fox to Campbell versus Acuff Rose. Mr. Band has also written extensively on intellectual property law, including a book entitled Interfaces on Trial about software and intellectual property, and over 60 articles. Drawing from this extensive experience, Mr. Band is going to discuss today how intellectual property law has evolved in the courts, in Congress, and in the international arena, in his lecture entitled Natural Selection or Intelligent Design, Personal Reflections on the Development of Intellectual Property Law. Jonathan?
Thank you very much. Thank you very much for having me. And I hope to spend the next 45 minutes sort of giving you a bit of my perspective on some of these issues, and then there'll be time for questions at the end. One of the greatest frustrations I've had over the past 20 years practicing law is that you often have a client come in to talk to a lawyer about a problem, and the lawyer, more often than not, will do some research and say, oh, the law is a problem in this respect or that respect, and the client is a little frustrated that he, that he can't do what he wants to do. Better lawyers will sometimes say, well, the law is a problem in this respect or that respect, but here's a way you can get around it, or here's a way, there's another way you can do it, another way you can structure your deal, or another way you can design your product that will get around the problem the law creates. And that's more helpful to the client because the client actually now has an idea of what they can do. But very few and almost no lawyers, and this includes at my old law firm, I was at Morrison & Forster for almost 20 years, very few lawyers will ever think about, to the extent that they understand that the law is an impediment, very few lawyers will ever say, well, why don't we change the law? The normal answer is, oh, you can't do it, or you need to do something else. But again, very, very few lawyers ever say, well, this exception doesn't apply, so let's change the exception. And this realization, how lawyers really don't think in those terms really struck me a few years ago. I was representing a client with respect to the Communications Decency Act in its second iteration, the CDA2 is what people call it. And we had come up with an exception for internet companies. And then late one night, I got a call from the client. He had gotten a call from the staffer of the relevant congressional committee saying, we need a definition. We need a definition. I don't even remember what it was for, but let's say for information location tools. And so, the client and I spent about 10 or 15 minutes coming up with a definition, and sure enough, that, was included in the markup the following day, and that definition is part of the U.S. Code. Now, someday, there will be litigation over that definition, again, because it's a definition as part of an exception, and, the courts are going to, there's going to be a lot of briefs back and forth. What did Congress intend when it formulated this exception? Now, of course, Congress intended nothing. The staffer intended nothing. I mean, I came up with the definition. But it will almost certainly not occur to the attorneys who are involved in this litigation. They're going to spend, someday millions of dollars on this litigation. It probably won't occur to them, well, maybe, we can't deal with it, worry about it this time, but next time, why don't we fix the definition? Why don't we spend $100,000, get the definition, fixed one way or another, and that way it'll be much more effective. So if nothing else comes out of my talk to you, if you don't get anything else out of it, it's the one point that once you're out in practice, don't, and your clients are encountering a problem with the law, you don't have to always take the law as a given. It's not the Torah given to Moses on Mount Sinai. It is something that can be changed and often should be changed. And the people who can change it are you, the people in this room. And so just always remember that when counseling clients, that there is always that other option that you can't take, you shouldn't take. You should never take the law as an immutable given, but rather it's something that is, it's a condition you have to deal with, but it's a condition that you can change if necessary. When I was emailing back and forth with Jennifer about what I should be talking about, she suggested that I tell some war stories. And so I figured, okay, that's always good. I like to tell war stories. Everyone likes to talk about themselves. But, since it's at a law school, I need to put it in a framework to make it seem more, intellectual and theoretical and rigorous. So I was trying to think of three different situations, three different war stories, really, and then I was trying to think of a way to tie them together. And I think there is a theme here that there are different, the law exists and operates in different areas, and it changes in different ways in different areas. And the process of change also varies depending on the context. And so in certain contexts, it really does follow almost an intelligent design approach. In other words, you really can sort of, there was a guiding intelligence behind the change, and the process made sense. You might not necessarily like the results. You might consider the results to be illogical, but at least the process kind of makes sense, and it did follow an orderly, logical fashion. In an orderly, logical fashion. On the other extreme, you do have some changes to the law which seem completely random. And even though, yes, the analogy between intelligent design and natural selection and sort of the randomness that is inherent in natural selection is flawed. You can only push that analogy so far, given that we're talking about the law, and obviously people are involved in all of that. And obviously people are acting as rational actors, but still, the process can be incredibly random, and things can happen that are totally unpredictable, and you get results that are not necessarily, or the focusing on the process, you get a process that doesn't always make a lot of sense. So on one extreme, sort of the intelligent design framework is when you're dealing with the U.S. government position in international negotiations. That tends to be a pretty rational process. Pretty much the way they come to their decisions is a pretty rational, intelligent design process. On the other extreme, you have Congress, which and legislation, which in my model is going to be a completely random process, and the decision making of courts is somewhere in between. Now, let's start with the negotiating situation. And a lot of it is, I think, it ends up being more rational, and especially if you look at going from international negotiating positions to courts to Congress, one of the reasons why it gets more random as you go, I think, is you just get more actors, more participants. And as you get more participants, more decision makers, the process gets more and more random and uncontrollable. But when the U.S. government is formulating its position in a negotiation, you ultimately have a very small number of decision makers. You'll have the United States Trade Representative. We're talking about intellectual property here, so you might have the Copyright Office, you might have the Patent Office. Within those offices, you might only have one or two people, and that's it. So it's a relatively small universe of people that are involved. And they also have real hard deadlines. They have, the next round of the negotiation is supposed to start by such and such a date, so they need to formulate their position by that date. So they have a real deadline, and they have a small number of decision makers. And so a recent example of my experience with this is, as you probably know, the United States is in the process of negotiating free trade agreements around the world. And in fact, that was a lot of the demonstrations down in Latin America were in connection to the discussion of a free trade agreement for the Americas, or a free trade area for the Americas. But the United States has already negotiated an FTA with Singapore, with Jordan, with Bahrain, with Chile, with CAFTA is with Central America. each of those free trade agreements includes a whole section on IP, and the United States typically goes in with a template of what they want the IP portion to look like. Now, the outcome of that negotiation can be somewhat random, if you will, because of the negotiating pressures and the trade-offs that the government makes. But certainly the position of the United States going in is kind of a coherent position. Now, again, there's a standard template that exists for all these FTAs. However, when the United States was about to engage in its negotiation for the FTA for Thailand, and I believe that that's still ongoing, a group of publishers came to the USTR and said, there's a big problem in Thailand with course packs, and the course packs are completely out of control, and a lot of it had to do with a particular decision that there was a judicial decision interpreting the Copyright Act, and it was interpreted in such a way that suggested that the wholesale copying for use of copyrighted works for use in course packs was completely okay, was not an infringement. And the publishers very much wanted to get a provision in the FTA that made it clear that you couldn't do that. But fortunately, the folks at the Copyright Office and at the USTR said, okay, well, again, any agreement that we come up with is going to be binding on both countries. It's not only going to be binding on Thailand, it's going to be binding on the United States. And so we need to make sure that whatever we come up with is something that's acceptable here in the United States. And so what they did, the folks at USTR, and I know actually it was the Copyright Office, sent me, and I was representing the library associations, and a colleague who's representing the universities, sent me the proposed language that the publishers had come up with. And of course, it was completely unacceptable. It was incredibly broad, and it would have prevented sort of any kind of classroom copying for any purpose whatsoever. So we sent an email back, and we pointed out, the 25 things wrong with the language that the publishers came up with, and there was kind of this and we proposed alternate language, and of course the publisher said, "Oh, no, that's too narrow. They're gonna, people will take advantage of it," and there was sort of an email back and forth, a couple of rounds, and finally they did what almost always happens in this kind of situation. The USTR said, "Okay, we need to have a face-to-face meeting," and so the USTR convened a meeting in the Copyright Office, in the Library of Congress. We sat around a conference room table there, and we sat down. And so on one side there was myself and then a fellow representing the universities, and then across the table were several publishers, and we sort of did a back and forth negotiation. The Copyright Office and the USTR sort of sat at the head of the table, and they acted as referees, and that again is the typical role of government staff in these situations, and also in Congress. They act as referees between industry lobbyists, and we came up with a provision that we could live with, that the publishers could live with, that achieved their goals but didn't, at least in our view, completely destroy classroom use in the United States. And sure enough, that provision then is now part of the U.S. negotiating position in the free trade agreement. And I think it sort of is narrow, and it focused on the issues. And once we signed off on it, and the guy from USTR signed off on it, that was the end of it. There was no other hoops to jump through. That was the official U.S. government position in this negotiation. Now, again, what happens afterwards in the negotiation, that's a totally different story. But at least in terms of how you get to what the position is, it's a relatively intelligent process with relatively small amounts of randomness. Now, what I'd next like to talk about is judicial decision-making. I had a client that was very worried in the late 80s and early 90s about software copyright and the direction that software copyright law was taking. And much of the problem came out of two Third Circuit decisions, Apple v. Franklin and Wayland v. Jaslow. There was a sense that the U.S. copyright law was moving in the wrong direction. And this client also was worried about what was going on in Europe. The Europeans were considering a software directive at the time, and there were provisions in that software directive that were also seen as problematic that would afford too high a level of protection and would make it difficult to engage in interoperability. Now, again, these days interoperability is like motherhood and apple pie. You know, you've grown up with the internet. You just assume that it's the way things should be. That computers made by different vendors should allow to interconnect, and you should be able to move data from one forum to from one computer to another computer, but made by another manufacturer. But in the late 80s and early 90s, that was by no means a foregone conclusion, and certainly the Third Circuit didn't think that that was the way it should be. And so what we did is a group of companies that had similar views formed an association. In Europe, it was called the European Committee for Interoperable Systems. In the United States, it was called the American Committee for Interoperable Systems. In Europe, it was very clear what needed to be done because there was this software directive. So they basically were a lobbying organization, and they went around and lobbied the various bodies of the European Union to try to get the directive, which is in essence like a statute or an over statute that all the national laws have to comply with, to get it to move in the right direction. In the US, it was less clear. There was no legislation pending. And so what the strategy we decided to adopt, given that all this was going on in the courts, was we would file amicus briefs, friend of the court briefs. Now, if we were really organized and had a bigger war chest, we would have done what supposedly the NAACP did in the years dealing with, leading up to Brown versus Board of Education, where at least the story goes that they had a very carefully orchestrated series of test cases around the country, and that led ultimately to cases before the Supreme Court, Brown versus Board of Education, other cases. I don't know if it really was that well orchestrated. Certainly in retrospect, it looks like it was well orchestrated. If you look at what we did in the late 80s, early 90s, it actually does kind of look well orchestrated, because the big problem with the Wayland v. Jaslow decision, which gave protection to the structure, sequence, and organization of computer programs, there were two aspects of that decision which were problematic. One was that the court really bought into the sweat of the brow approach, saying, gee, it's hard to write a computer program. You spend a lot of time thinking about it and organizing it, and therefore the organization obviously needs to get copyright protection. They also said, well, copyright, a computer program is a literary work, and as a literary work, it should receive as much protection as a novel or a play. Literary works get a lot of protection. And then the Feist decision came along, the Supreme Court's decision in Feist versus Rural Telephone, and the Supreme Court there said, no, sweat of the brow is not part of copyright law. And also, again, remember, Feist was the case involving the telephone directory, the white pages. The court said sweat of the brow is not part of the copyright law. And second, they said, yes, a directory is a literary work, but not all literary works are the same. Fact works get less protection than fanciful works. So a directory gets thinner copyright protection than does a novel or a play. And sort of building on that, there were then a series of cases. There was Computer Associates v. Altai, and then Sega v. Accolade, and this group, ACES, we filed amicus briefs in all of those cases, in Computer Associates v. Altai and Sega versus Accolade, and some of the cases after that. We also filed amicus briefs. We also were involved to some extent with Feist versus Rural Telephone. I participated in the moot court for the attorney in Feist, representing Feist, and he had lost in the 10th Circuit, but he won before the Supreme Court. And so again, it sort of looks like we had this very careful strategy. The truth is we were completely reactive. Feist came along, we said, gee, that would be a good case for us to help out with. And then Computer Associates came along and said, oh yeah, we need to file an amicus brief in that case. And after that, it was always very much reactive. We reacted to the situation. And again, we were filing these amicus briefs. It's hard to tell whether amicus briefs really make a difference. Certainly you tell your clients it makes a difference, otherwise how could you justify them paying for it? And I am sure it makes some difference on the margins, and so you can help influence the direction of cases. Obviously, the best way is to bring the test case, but that takes a lot of money, and someone has to be willing to lose. It's a much lower budget way. A lower budget way is again to do what we did, file these amicus briefs. But at the same time, again, a lot of other factors can intervene. You say, okay, there is obviously when you're in litigation, you do have a relatively clear process. You have the trial court; it goes up on appeal. You have judges who have a relatively small number of decision makers. In theory, they look at the merits, and then you can try to influence the merits by filing these amicus briefs. But again, you also often have other factors that inject a degree of randomness. And certainly in the Sega v. Accolade case, which is the famous reverse engineering case, it had to be important that the plaintiff was a large Japanese entertainment company, Sega, and that the defendant was a small U.S. computer game company, Accolade. And this was in the early 90s when the United States was very worried about its competitiveness vis-a-vis Japan. And so that obviously had to have, I'm sure, some influence on the court. Now, I'm sure the court looked at the brief our group filed, and I'm sure the court also looked at a brief that was filed by a group of law professors. And especially the law professor brief was a fabulous brief. Dennis Cardula from Arizona State University Law School took the lead in writing that, and I'm sure that was influential. But again, there's no way to tell to what extent we were able to influence the process, but at least we would like to believe that we had some impact. Now again, it was no accident that Dennis Cardula filed that amicus brief, and it indeed is rarely an accident when groups file an amicus brief. Usually the parties go around trying to convince people to file an amicus brief on their behalf. In this case, actually, the fellow who ran ASIS, Peter Choi from Sun Microsystems, what he had done is he had, over the years, talked to a lot of law professors, including some in this room, and had sort of educated them or talked to them about it, and was educated by them, and he sort of brought the Sega v. Accolade case to Dennis Cardula's attention. And a lot of times you need to have that happen, meaning you need to have someone go around and beat the bushes. Sometimes, again, it's the party itself. Sometimes it's someone who's interested in the litigation, and you get people stirred up and file the amicus briefs. Now, again, who knows how much impact the amicus briefs have, but actually, hopefully it does have some impact on the margins, and it's again, you would like to think that it does somehow have an impact on this decision-making process. Now, the last thing I'd like to talk about, the last area, and I'll talk a little bit more about this area, is the area of legislation, and that's the area that's, in my view, completely random. That there is nothing approaching any sense of intelligent design with legislation. Now, it does start out in a kind of intelligent way, not maybe a way you like, but it does start out intelligently. Typically, what will happen with any piece of legislation is some lobbyist, it could be me on one side, it could be someone from the recording industry or the Motion Picture Association on the other side. Some lobbyist will draft a piece of legislation. Now, that's typically when you're dealing with any kind of civil copyright bill. If it's a criminal bill, sometimes the Justice Department will get involved, and they might actually start it out, because they're the ones who bring the criminal actions. But certainly, any bill that deals with civil remedies for copyright almost always is hatched in the mind of a industry lobbyist, and then they'll go to the relevant subcommittee, the House IP subcommittee. Now there's a Senate IP subcommittee, and they will convince someone on that committee to go ahead and introduce the bill. Now after that, so there you do have sort of an intelligent design. You have someone saying, okay, this is the bill I want introduced, and they get it introduced. But what happens after that is where you get this incredible process that gets completely random. Usually, you can be assured that any bill that the MPAA or the RIAA wants has a lot of problems in it from the point of view of the tech community and sort of the public interest community. And so the problem is how do you fix the bill? And the good news is that the process in Congress is so convoluted, and it sort of wends its way. It has to go from the subcommittee, let's say the bill's introduced in the House, so it goes to the House IP subcommittee, then it goes to the full committee. Then it has to get approved by the Rules Committee, in essence, before it can get to the floor of the House. And then you have the same process on the Senate side. It has to go typically to the IP subcommittee, to the full committee, and then it needs to be approved by leadership before it can get to the floor. So what you have to do is, if you don't like the bill that gets introduced, and to a large measure, I'm sure it's no surprise to you that the IP subcommittees more on the House side, but to some lesser extent on the Senate side, are to some extent captured subcommittees that they see their constituencies mainly being the patent industries and the copyright industries, not the users. They will pretty much do, with relatively minor changes, what the copyright owners suggest that they do. But then the key, if you don't like that piece of legislation, is to find some place along this long, windy road where your issue, your concerns can get some traction. And it's completely unpredictable where you'll get that traction. And in fact, in every bill, your issue gets traction in a completely different place. Sometimes, for example, in the database legislation, which nothing is going on in that area now, but has been in the past a huge fight, we were never able to get any traction. My clients were never able to get any traction in the IP subcommittee which is part of the Judiciary Committee in the House, but we were able to get interest over in the Energy and Commerce Committee. And so what we did is we got the Energy, we worked with the Energy and Commerce Committee, and they would introduce a counter bill. And then those two bills, in essence, the Judiciary Bill, Commerce Committee bill, established a deadlock. Other times, you would go to leadership and explain to leadership why this bill was very controversial, why it was a problem, and the bill simply would die right there. Especially on the House side, leadership is very strong. If leadership thinks that something's going to be controversial, that's where it will end. And so then again, to the extent that you're representing public interest groups, let's say I represent the library associations, if you're dealing with a Republican Congress, what you need to do is find business allies. And if you get the business allies and get businesses to say this is going to be a problem, then again, you can either get a roadblock or at least have someone say this bill will not go any further unless there's a negotiation, unless these interests are addressed. So you have to convince people that your issue is legitimate, but more importantly, you have to convince someone in this process that you have enough political juice that it is important for them to listen to you and take you seriously. But again, in every time, the key, as bills are going through Congress, the key, to the extent you're trying to fix something, is how do you find the pressure point? How do you find some point somewhere along the way where you can get some traction? Now, the first time I really got involved in legislation, originally when I was doing the policy work, was mainly with this group ACES that I was alluding to before, writing amicus briefs. I really got involved in the legislative arena with the Digital Millennium Copyright Act. So this is now back to starting in the 1995 time frame. But the legislation really got going after the WIPO diplomatic conference, where the copyright treaty and the performance and phonographs treaty were adopted. That was in December of 96. So then came back in 97, and that's where 97 and 98 were the main years of the DMCA legislative battle. And my clients were very concerned. Again, it's the same clients as before. The folks who wanted to develop interoperable software were very worried about the issue of reverse engineering. Okay, so again, the same issue with Sega v. Accolade. We had won in the courts in 92, but we were afraid that the DMCA, by prohibiting circumvention, would, as a practical matter, would prevent the reverse engineering that was permitted as a fair use under Sega v. Accolade. So we were trying to preserve our earlier victory. But we knew that if we went around saying, oh, we just want to, we have a problem just because of reverse engineering, we realized that would be too narrow, that was not enough of an issue to get traction on. Also, in those days still, it's changed since then, but certainly in those days, reverse engineering was still seen as something kind of a bad thing. It was kind of like a dirty phrase, reverse engineering. No one didn't understand what it was. When you sort of explained it, they said, oh, but isn't that wrong? You're sort of stealing someone else's ideas. I think Congress has since gotten a little more sophisticated, and I think in part, large measure, because you have a whole new generation of staffers, and so Sega v. Accolade was still very new, and then also the other cases like Atari versus Nintendo were very new in 96, 97, 98. But now, people, now a lot of people who are in Congress have gone to law school and actually studied about those cases in their copyright courses. And so, again, it's the Torah from Sinai attitude. If a case is in the case book, it must be right? I mean, it's part of the law, and therefore part of this unchangeable, immutable fabric of American life. So and Sega now has achieved that kind of status, but still in 96, 97, 98, it hadn't quite achieved that sort of immutable status in the minds of attorneys, and so. We realized if we talk too much about reverse engineering, people, their eyes would glaze over again. These are people who have no technical background by and large, and it was too narrow. So we had to come up with other examples of problems with the DMC, other places where circumvention or a prohibition on circumvention could be a problem. And we try to talk to technology people, but I got to tell you, I mean, that is the most frustrating thing in the world, to try to talk to a technology person and come up with and get them to understand a legal issue and a legal problem and think hypothetically. It just doesn't work. It's a very, very frustrating process. Because they also say, well, that's stupid. And you say, okay, I know it's stupid, but that's what the proposition, but that's such a stupid idea. Why would anyone, I know it's stupid, but tell me, how is it going to affect you? Oh, it's just dumb. I don't want, and that's it. They won't tell you, okay, give me a specific example of something that you are doing right now. How would this prohibit it? They're just so, they can't get past the stupidity of the proposal, and to sort of explain to you in understandable terms why it's stupid and what the impact will be. So I was in the unenviable position. Again, I don't have a technical background. In college I majored in social studies. That was the name of my major, and yes, that is what you studied in third grade, and and I never got much beyond that. And so that was my, that's my background. And so but I had to come up with examples. And so I sort of just started making things up. I mean, there's no other way to describe what I did other than I was making things up. And I said, oh, this is going to have all kinds of bad privacy implications. So this is going to have all kinds of, now you say, well, shouldn't it be the opposite, given that you're prohibiting a circumvention of technical protections, then should that protect privacy? But that was a minor detail. Then I knew that you also needed to have that if you wanted anyone to get interested in something dealing with the internet and technology, it had to have some connection to porn. And so I came up with this crazy rationale about how this would interfere with a parent's ability to monitor what their kids were doing. So if your kid was accessing some kind of protected website, they had a password, but you wanted to know where they were going. I mean, okay, so. And then I had a sense that I knew that there were people who were doing encryption research, but I had no idea who these people were. And again, we tried to reach out to them, and they just again said, "Stupid. This is stupid," and that was it. We said, okay, encryption research. This has to have bad implications for encryption research. So then we, basically wrote up a white paper that said, this prohibition on circumvention is going to be really bad for all these reasons, pornography, privacy, encryption research, and oh, by the way, reverse engineering too. And we got no traction, absolutely no traction on the House side. On the Senate side, we started to get traction in the most oddest places. Ashcroft, Senator Ashcroft, who was then senator and then he subsequently became the Attorney General, Senator Ashcroft was very interested in the pornography provision, of course. And he said, oh, we've got to do something about the porn. Hatch got very interested in now when I say Hatch, and what I mean is his staff. I mean, I don't know if he ever thought about it, but you typically, what you do is you meet with staff and you explain, you tell the staff, this is a problem, and these are the people I represent, and then they might talk to the boss, they might talk to the senator and say, okay, these guys have this problem, these are the people, and he might, it might rise to the level, or it might just never even get to the senator. It could be that the staff, purely acting on behalf of the senator, decides that it's a legitimate issue, and that the people you represent are important enough that this will be good for the senator to act in such and such a manner. And again, I don't know, and this is where there is a great mystery about what goes on in Congress, because I don't know for sure exactly why Senator Hatch decided that this was important, but he did. And you can speculate, you can say, well, and again, this is kind of the randomness, where the randomness enters in. When we were talking about reverse engineering, at that point, Microsoft was involved in litigation with Novell. Novell is a Utah company. Hatch is a senator from Utah. It was suggested that this was a reverse engineering provision, is something that Microsoft wouldn't want, but Novell might want, even though actually Novell at the time was lobbying against it, but that's a minor detail. Again, the merits don't really matter too much in this process. But Senator Hatch understood at some level that this was a good thing. It was pro-competitive and anti-Microsoft, and therefore it was good. And so he basically, his staff told the folks from the Business Software Alliance, which is large, a trade association dominated by Microsoft. Hatch said, or the staffer said to them, you need to work out something on reverse engineering. And the bill didn't go forward until something was worked out on reverse engineering. And then there was a process. I was on vacation at the time. And a lot of things in Congress sort of hurry up and wait. They'll say, okay, we need you to work out something. We need you to work out a deal on reverse engineering by next Thursday, because we're going to have a markup. That's when basically the committee votes on a bill, and we need to have it done by then. And so you, of course, rush, and you get it done, and of course the markup is canceled and doesn't happen. And then you hope that the deal doesn't unravel. But you have a lot of artificial deadlines of that sort, again, which is another part of the randomness of this process. There's a lot of hurry up and wait, false deadlines, but you have to reach them. So in any event, I was on vacation, but we were sort of told we needed to work out a deal by the following week. And in those days, I don't think we did it by email. This was still in the 90s. So we were using faxes, and we were sort of faxing language back and forth. And I was visiting my brother-in-law who lived in Colorado, and luckily he had a home business, so he had a fax. Again, even fax machines and home fax machines were less common in those benighted days. And so I remember, we were sort of faxing things back and forth, and then after that we went to Moab, Utah, and luckily the motel there had a fax machine, and so we were sort of faxing drafts back and forth, and we reached, had conference calls, and we were able to reach an agreement, and the provision, the reverse engineering exception in the DMCA 1201F is, the product of that negotiation between my client and the Business Software Alliance. That's where it came from. But interestingly, this is the problem when you're sort of advocating a broader range of things that need to be fixed. As I said, we not only talked about reverse engineering, we also talked about encryption research. And all of a sudden, Hatch's guy said, and we need to fix encryption research too. We're convinced that's a problem. And so then we were sort of like, okay. But the truth is, I didn't have any clients who cared about encryption research. But they were, we had succeeded, and it turns out, ironically, that probably the biggest problem with the DMCA is encryption research. I mean, that even though I just made it up in my shower one day, that it was a real problem. It's just like, the expression, just because you're paranoid doesn't mean they're not out to get you. I mean, just because you made it up doesn't mean it's not true. And apparently it really is a very big problem. And so we then we were again told, I think we were told like on a Friday afternoon that we needed to have encryption research language worked out by Monday. And again, the problem was we knew nothing about encryption research. I don't think the BSA knew anything about encryption research either. Everyone tried to find an encryption researcher to help, to guide us, and again, the typical, well, that's stupid, we couldn't get anything useful about, okay, well, tell me what you do, and how do you do it, and what do you need, and I need everything, or, it would be very, very unhelpful guidance. And so we then, literally it was around, because we had to do it over a weekend, and we sort of figured out that most of us lived in suburban Maryland, that we ended up meeting on a Sunday afternoon at my dining room table to work out the encryption research exception in the DMCA. And again, it was all made up. We didn't know what we were doing because none of us knew anything about encryption research. None of us had been able to get any of our clients or anyone in, any of the engineers in the clients to articulate anything useful other than it was dumb. And so we came up with with an exception. Now, I know subsequently a lot of encryption researchers have criticized this exception, and they're saying it's stupid, and I'm saying, well, gee, thank you very much, but but you're lucky that you have any exception, and moreover, where were you when I needed you, but that's how, in any event, that's how that provision was included in the DMCA. Now, a final little ironic anecdote. As you may remember, I don't know if you've to what extent you've studied about the DMCA, but when it passed the House, it had 2 additional titles. It had, there were 4 basic titles, and then it had, at the last minute, they added a title dealing with boat hulls, critical issue to the, actually, I think it's probably pretty important to the North Carolina economy, but not to anyone else. And so there was a provision dealing with boat hulls, and extending protection, design protection to boat hulls. And there was also a provision dealing with database protection. And it was a provision that was heavily based on the EU Database Directive, and both of these passed the House. They were part of the DMCA as passed by the House. Now, when it went over to the Senate side, and again, I was also representing folks who were very concerned about the database provisions, we had gotten no traction on the House side, but on the Senate side, again, and there's a variety of reasons. You're often going to get more traction on the Senate side, largely because the way the Senate's set up, if you get one senator to express even mild interest, that's enough to throw a kink in the works, and so, often that's where you get your traction and things get fixed when things get over to the Senate side. We'd had this whole long negotiation with the database producers, and we ultimately weren't able to reach an agreement. And so at the end, the database provision was not part of the Senate bill, nor was boat hulls. And then the bill went to conference, so you had 6 titles in the House bill. You had 4 titles in the Senate bill, again, the difference being databases and boat hulls. And then there was a conference. And so we were, really afraid that out of what would emerge out of conference would be the House bill, that somehow databases and boat hulls would get attached. Now, I wasn't there, so this just might be a story. But the story, what I heard is that Senator Hatch, before he went into conference with the House conferees, had been briefed that there were a lot of problems with the database provision, and there were not yet consensus. Boat hulls was less controversial, and supposedly there was a meeting between Howard Coble, who was the chairman of the House IP subcommittee, and again Hatch, the chairman of the Senate Judiciary Committee, and they were working out the details of the DMCA. And again, you don't know how scary that is when you actually have members of Congress making these decisions, because at least they really typically have no idea what's going on. I mean, the staff has some idea, but even then, you're dealing with very technical stuff. It's often, again, like I said, the lobbyists have done the lion's share of the drafting and the negotiating, and the staff acts as referees. So the story goes, again, I have no idea if this is true, that Coble was talking to Hatch, and Coble said, and Hatch said, I have, serious problems with databases and boat hulls. And Coble supposedly said, well, I need one of them. I need, I have to have at least one of those two. And then, Hatch had to choose which one got to stay in and which one didn't. And so you just have these, you can imagine him trying to remember what his staff had told him, now which was the good one, which was the bad one. And luckily, he picked the right one, meaning he said, okay, we can leave boat hulls in. And so boat hulls is the 5th title of the DMCA. And it's, I don't know how helpful it's been to the North Carolina economy, but it really has not caused serious problems. If databases had been part of the, if databases had been included, that would have been a very big problem. I think all of us would have been feeling its repercussions. So thank God Senator Hatch picked the right title to stay in and picked the right one to go out, but if you can't imagine anything more random than that as to what would stay in and what would stay out. Now, the final little anecdote I want to tell you is even when all the details get worked out, things can still happen. So, for example, at the end of last Congress, there was an omnibus IP bill, a bunch of little provisions that had sort of been strung together. The most controversial provisions had sort of fallen away as it had gone through the process again. People had raised concerns, or other provisions had been negotiated or negotiated down. And so finally, it went through the House, went through the Senate. The Senate kind of tinkered with it more and got the bill to a relatively narrow bill that wouldn't be too problematic. John McCain at that point decided that it was the issue of boxing on Indian reservations was a very serious issue, and he felt, again, he was about to lose his chairmanship because of term limits. He was about to lose his chairmanship of the Senate Commerce Committee. He decided that the boxing commission, and apparently there is already something in the U.S. Code that deals with boxing commissions, but this would dramatically expand the scope of this boxing commission. He started adding it, and he was somehow able to add it to just about every bill that was going through Congress. And so he did, in the end, add it as a new title to this IP bill. And they say it really had nothing, again, had nothing to do with IP, but he just found it as something to attach to the IP bill. Because it attached to the IP bill, that made it sort of bollocksed up the work, and they just ran out of time. There's a lot of chaos at the very end of a congressional session, and they simply, because the Senate bill had this boxing commission title, the House bill didn't. There was no time for a conference, and so the legislation died. That happens a lot. Crazy things happen, things get attached, and then there's just no time to smooth things out. Now, what did happen at the beginning of the next Congress, the 109th Congress that started this past January, is because, again, the deal had held, no one had sort of backed out of it, and so Congress did, the House and the Senate each quickly repassed the bill, and it's been signed into law. But again, this sort of the McCain tactic is not uncommon, where something gets attached, and again, that's a highly random process. So, as I've indicated, you can change the law. The change might not always be what you expect, and might not even, and especially when you're in the legislative arena, the process by which you get there can be completely unexpected. But it is a very, very interesting journey. Thank you very much. I'm happy to answer any questions you may have. Yes, Professor Boyle?
So I was quoting from my class the other day the great Bismarck adage that people who like law and sausages shouldn't watch either being made, and I think you've put me off sausages for life. Two questions, or I guess sort of rolled into one. Is what you're describing decreasing levels of rationality or decreasing levels of predictability? Because I have to say that the word that I would use to characterize the USTR's position over the years would not be rational. I mean, that's not the first adjective that springs to mind. Nor even in terms of the particular issues that they push in terms of whatever importance to the American economy or benefit to the consumer or benefit in terms of structuring the long term, any of those, right? That none of those really come to mind. And on the flip side, if what we were saying was that what happens in Congress is random, and obviously, I mean, from your very entertaining stories, it is there are lots of things that happen. It would be surprising if all policy nevertheless went in one direction. And yet our policies have fairly resolutely marched towards expanding and expanding and expanding IP. And the answer to that might be, well, the big companies control it, but many of the people who you've represented, I mean, you've more often worked representing the hardware side, so by my count, that's about $750 billion out of the American economy, and the content side is about 80 billion. So if what we expect was that, in Congress you get the best law your money can buy, you would expect a very different package of laws than the one we've actually got. So as I'm listening to what you're saying, I mean, I understand what you're saying is this is a chaotic process. Butterflies' wings can disrupt, the weather in Washington, fair enough. But if that's true, and if actually even just the material forces, just the amount of raw potential campaign dollars out there, or the size of the industries, doesn't seem to predict the outcomes, why are the outcomes actually relatively consistent? Because if it's so random, and the money is actually more on the side of the hardware side, we would expect to see the opposite trend than we've had. It seems not random, it seems patterned, and it seems patterned in a weird way.
Yeah, well, those are several different thoughts. One is what I was suggesting is that the process at the USTR was more logical, not necessarily the outcome. And it's more of a rational process because there are fewer decision makers, there are fewer people coming in, and again, what they decide to do is ultimately a political decision, not a completely rational policy decision. But it is a somewhat what I'd call a somewhat rational policy in that it's relatively streamlined, relatively few people making it, and you don't have things like the boxing commission. I mean, things coming totally out of left field. I mean, now that might happen at some level when they do have to decide, okay, when they're putting together their overall proposal and what are they going to push harder on, what's more important, and those kinds of trade-offs. I mean, that does happen. But even again, those are decisions that are made by either the USTR, or if it gets a very political, might get decided in the White House. But that's so much more centralized and streamlined than what you have in Congress, which is the complete opposite. But there's no question that one can question the logic of and the rationality of the policy. I was focusing more on the process. Now, with respect to Congress and sort of this general trend, I think there's a lot of reasons that might factor into why there has been a overall trend in favor of the copyright owners. Certainly, and you're right, it is at one level sort of remarkable, given that the copyright industries and the traditional entertainment industries are so much smaller than the IT industry. And I think there's several reasons for that. One is that the copyright issue is a much more important issue for the entertainment industry than it is for the technology industry. The technology industry has lots of concerns. And so whereas for For Disney, copyright is the number 1, 2, and 3 issue. For Verizon or for IBM or for Intel, copyright's important, but it's one of, they care a lot about H-1B visas, and they care a lot about, all kinds of tax issues, and what is the accounting treatment for stock options? I mean, and so they have other priorities, and then even in the government affairs office, they sort of have to decide what is the top priority, but I don't think for any of those companies is copyright number 1. It might be number 3, but there's a big difference if it's number 1 for Disney, number 3 for Intel. That to some extent explains the difference in outcome. I think the other factor is that even though Intel and the other tech companies are a bigger chunk of the economy by and large, on the whole, the technology industry just doesn't spend as much in Washington, and especially if you say percentage of the revenue of the companies and so forth, they just don't spend it. There's been there's a historical aversion towards public policy by folks in Silicon Valley, and it's just a different view of the world. I think the folks in the entertainment industry realize that they need to fight in this arena, and they fight hard, and the folks outside it. Now, and the last point I'd make is that even though we see, and I agree with you that there's, you could sort of see a trend in towards more protection. If you were to ask your typical attorney who represents the entertainment industry, I mean, they would, again, paint this sky is falling scenario about how, yes, maybe there might be a little bit more protection on the books, but as a practical matter, they have far less protection because of the internet and, all the file trading and so on and so forth. And so they'd say that as a practical matter, there is far less protection for intellectual property now than there was 10 or 20 years ago.
So we have time for one
Okay.
more question.
Yes, please.
Certainly, it seems like reverse engineering is an important issue for a lot of different companies, but I was wondering if there was any congressional attention as to shrink wrap licensing and its common prohibition on reverse engineering. I know it's been addressed in some circuits, but not.
Yeah, it's it's funny. We talked about this a little bit at dinner last night, and I was saying sort of like the big problem, the huge problem is EULAs and the end user license agreements, and how we might end up with great court decisions and we might end up with great statutes, but if courts are enforcing these shrink wrap licenses and browse wrap and click on licenses, then we all have a very big problem. And you're completely right. It has received very little attention. Every once in a while, we're able to get someone to think about it or focus on it a little bit, but part of the problem, it's been difficult to get more attention, is that a lot of the tech companies who would be interested in ensuring reverse engineering also use shrink wrap licenses against their consumers all the time, and so they have this internal trade-off, and they have to sort of decide, well, what are we more worried about? Are we more worried about are we more worried about screwing someone or getting screwed? And so, I mean, to put it crassly, and so that might be, as a result, they haven't done it. I think it's going to be very hard to do that because, what you're really, anything that goes to licenses, there's two problems. One is that is treading on state law, and certainly in a Republican Congress, there's great reluctance to do that unless it's anything dealing with abortion or social issues, but certainly any kind of technology issues, there's a great reluctance to trample on state law. And then I think there's always been this notion of the freedom of contract. It's in the Constitution, and so there's this hesitancy to do anything that would in any way interfere with the freedom to contract. And so, but I think at some point it's going to come to a head. Now, what might happen is it might come to a head first in the courts, meaning if you have like the Bowers v. Bay State case, and then there was the Blizzard case. One of those cases eventually will get, the court will grant cert perhaps, and at that point the Supreme Court might say, well, boy, it really doesn't make any sense to have all these lovely copyright laws if you can just erase them by virtue of a unilateral license, and something that really isn't negotiated and so forth. So it could be that the problem would be taken care of at that level. I just think the politics in Congress would be very complicated, and I don't, unless again you got a Supreme Court decision that was clearly, went one way too far or the other way too far, then you might be able to get some congressional attention. But until there is a Supreme Court, until the Supreme Court addresses it, I just think it's highly unlikely.
Thank you, everybody. Thank you.